If you live in Florida, own property in Florida, invest in Florida, or you're thinking about buying here, July 1st is not just halfway through the year and somehow still 97 degrees. It's also the day a whole batch of new Florida laws takes effect. And while not every new law affects real estate, several of them absolutely do, especially when it comes to building permits, affordable housing, development approvals, mobile home ownership, CDDs, veterans housing, and even privacy around code enforcement. So today I'm breaking down the real estate related Florida laws that changed as of July 1st. In plain English, no Tallahassee decoder ring required. Quick disclaimer, this is not legal advice. This is a practical, consumer friendly overview. For your specific situation, talk to an attorney, your local building department, or the appropriate professional. The first big one is House Bill 803, dealing with building permits and inspections. This law is aimed at cutting some of the red tape around permitting. And honestly, in Florida, anything that makes permitting less painful deserves at least a slow clap. The bill requires more uniformity around building permit applications, addresses timelines, private provider inspections, reduced fees in certain situations, and permit expiration rules. It also says certain single family permits expire after 1 year or when the next edition of the Florida Building Code takes effect, whichever is later. For homeowners, the headline is this: local governments now have to exempt certain owners and contractors from permit requirements for work below a specified dollar threshold with exceptions. The law also makes clear that projects cannot just be split into smaller pieces to dodge permitting. And very Florida specific, it also addresses temporary residential hurricane and flood protection walls or barriers, which matters because storm prep here is not a hobby. It's basically a second job with plywood. Why does this matter? Because permitting delays can affect renovation timelines, insurance repairs, closings, and even whether a buyer feels comfortable moving forward with a property. For buyers, still ask about permits. For sellers, still disclose known work. For owners, don't assume no permit needed means do whatever you want and hope for the best. Florida will find you, probably through a neighbor named Gary. House Bill 803 became Chapter 2, 026-63, and is effective July 1st, 2026. Next up, House Bill 1389, the latest update to Florida's Affordable Housing and Live Local Act framework. This one is more development focused, but it matters because it affects future housing supply, and housing supply affects pricing, affordability, rentals, traffic, schools, and local planning debates. The law expands where certain multifamily and mixed use affordable housing projects may be allowed, including certain property owned by counties, municipalities, school districts, and in some cases, religious institutions. It also limits some ways local governments can block or shrink these projects. For example, the Senate summary says local governments can't use other dimensional rules, like setbacks or stepbacks, to effectively restrict height on certain live local projects. It also strengthens protections against discrimination in land use and permitting decisions when the development is for affordable housing. Here's the consumer translation. The state is continuing to push local governments to allow more housing, especially workforce and affordable housing. Whether people love that or hate that depends on where the project is proposed, because we need more housing and not next to my house have been Florida's unofficial duet for years. For buyers and homeowners, this means you should pay closer attention to surrounding land use, not just what's there today, but what could be allowed in the future. House Bill 1389 became Chapter 2026-179 and is effective July 1st, 2026. Another development related law is House Bill 927, dealing with local land planning and development. This law requires certain counties and municipalities to create a program for development pre application consultation services. It also allows local governments to use qualified contractors or contractor firms for those reviews and requires a registry of qualified contractors. In real world terms, this is designed to make the early development review process more predictable and hopefully faster. Why should regular homeowners care? Because slow development approvals can limit housing supply, and limited housing supply usually means higher prices. This law is one more sign that Florida is trying to speed up the front end of development review. House Bill 927 became Chapter 2026-64 and is effective July 1st, 2026. Next is Senate Bill 686 about agricultural enclaves. An agricultural enclave is basically a pocket of agricultural land, mostly surrounded by existing development. Under this law, the owner of qualifying land can apply for certification and, once certified, may submit development plans for single family housing consistent with surrounding land use. Local governments also can't make the rules for these enclaves more burdensome than comparable applications. This could matter in growing areas where you have old agricultural parcels surrounded by newer neighborhoods. Translation: some land that has looked undeveloped forever may now have a clearer path toward single family housing. The law's agricultural enclave provisions are temporary and expire January 1st, 2028, unless extended or changed later. Now let's talk about Senate Bill 594, which is a big deal for mobile homeowners. This law requires local housing assistance plans under the SHIP program to include a strategy for helping mobile homeowners, including help with lot rent. It also says lot rental assistance is an approved homeownership activity, but it cannot exceed the equivalent of 6 months' rent. It also allows certain funds to be used for rehabilitation or emergency repairs of mobile homes and removes the prior 20% cap on using SHIP funds for manufactured housing. That matters because mobile homeowners can own the home but still rent the land underneath it. When lot rent jumps, it can put people in a tough spot fast. Senate Bill 594 became Chapter 2, 026 173, and is effective July 1st, 2026. Another important housing law is Senate Bill 1602, creating the Homes for Veterans Property Management Incentive Pilot Program. This pilot program applies in Broward, Escambia, Hillsborough, and Santa Rosa counties. It allows participating landlords to apply for funding to hold a vacant dwelling for a veteran for up to 45 days, and it can also help cover certain property loss beyond the security deposit, up to $2,000. The goal is to encourage more landlords to rent to veterans who are trying to secure housing. For landlords, this is one to watch. For veterans, this could create more opportunity. For the rest of the state, this is a pilot program, so if it works, don't be surprised if people push to expand it. Senate Bill 1602 became Chapter 2026 125 and is effective July 1st, 2026. If you live in a community with a CDD, Senate Bill 1180 matters. It creates a recall process for certain community development district board supervisors. So residents in CDD communities may now have a clearer process to remove certain board members through recall. There are also new laws around code enforcement, body cameras, and privacy. Senate Bill 504 requires policies when code inspectors use body cameras, and Senate Bill 506 creates public records protections for certain recordings inside private residences or places where a person reasonably expects privacy. And House Bill 655 creates a public meeting exemption for government agencies meeting with their attorneys about Burt Harris Act property rights claims. That matters when private property owners are challenging government action that may affect the use or value of their property. So, what's the big picture? Florida is trying to do three things at once: speed up housing production, reduce some permitting friction, and put more tools into housing assistance programs. But here's the real talk: new laws don't automatically mean lower prices, faster closings, or easier insurance. They create tools. How those tools actually work depends on local governments, funding, implementation, and, because this is Florida, probably 3 committee meetings and one very spicy Facebook thread. Also, two things people may hear about but should not confuse with July 1st changes. The major ADU mandate did not pass, and the big HOA/condo reform bill did not pass this session. So before you buy, sell, renovate, invest, or panic over something your neighbor posted online, get the facts. And here's my practical advice: if you own property in Florida or you're planning to buy here, don't just look at the house. Look at what's happening around it: zoning, development, permitting, CDDs, HOAs, affordability programs, insurance, and future land use. Because in Florida, the property you buy is only part of the story. The rules around it can change the whole plot. If you're buying, selling, investing, or trying to understand how these new Florida real estate laws could affect your next move here in Northeast Florida, reach out to me. I'll help you cut through the noise, ask better questions, and make smarter real estate decisions. I'm Trudy Padilla with True Dat Can Sell That, helping you make smart moves in Jacksonville, St. Augustine, St. Johns County, Palm Coast, Flagler County, and throughout Northeast Florida. The rules may change, but the goal stays the same: make smart moves, not expensive guesses.